9-0 or 5-4 doesn't matter. A loss is a loss. It ratchets everything up. The very fact that we're in front of a jury means something bad happened. Let us do what we do and take your vetting standards out of the contracts. We don't see this in any other aspect of the economy, right? Where, you have a legal duty to disclose your rates to a downstream provider. If I were to ask you as a broker, what's your carrier selection policy, and you tell me the system that you're using, then we need to talk, right? Like, the system is not your carrier vetting.
Welcome to Freight Beat, a podcast from the Transportation Intermediaries Association. I'm Merritt.
And I'm Patrick.
And every week we talk with the people who shape freight, logistics, and how this country moves. Today's episode continues the discussion on the landmark Supreme Court decision, Montgomery versus Caribe, and how the ruling moved the legal ground under the entire brokerage business.
Our guest today is Nathaniel Saylor. He's a partner at Scopelitis, Garvin, Light, Hanson Feary, the transportation law firm. Nathaniel represents brokers, forwarders, and technology-enabled logistics providers. He also wrote Scopelitis' case notes on Montgomery as it moved from the Seventh Circuit up to the Supreme Court. So, Nathaniel, thank you so much for being here with us today.
Yeah, my pleasure, gentlemen. Thanks for the opportunity.
So let's just get right into it. So you followed this case up close and personal, and you wrote about it at every stage. Obviously, this is a complex case, and just for the listeners out there who are curious or might, not know as much as you, what actually happened during that case? How did a traffic accident on an Illinois highway end up ostensibly rewriting broker liability?
Right. So, really, ironically, not a lot actually happened in the case itself, right? I mean, certainly we're going to talk about what the Supreme Court did and what they held. But as far as the case itself goes, there was a lawsuit against, personal injury lawsuit against the motor carrier. They pulled in, obviously, the broker in the case. The broker moved on in the litigation for preemption, arguing that, hey, the claims against me as the broker are preempted by federal law. They, won that argument at the Seventh Circuit, and so that was then appealed to the Supreme Court. The Supreme Court does not take very many cases, certainly didn't have to take this one, but they did take the case up, and obviously we got the decision that we got. But as far as the underlying facts in the case, it was a very run-of-the-mill highway accident claim. This one just happens to be the one that finally the Supreme Court selected, and they selected it because there was a split amongst the various U.S. federal circuit courts of appeals. So really nothing out of the ordinary with the underlying case. And, like I said, there was no trial on the merits on the broker's liability. They moved preemption early on. And because of that, that's why the case went to the Supreme Court and now has been remanded to the trial court for the actual trial.
So the decision was written by Justice Amy Coney Barrett. It was a unanimous decision. I kind of wanted to first. I was curious. Does the fact that it is unanimous really carry any additional weight? I mean, we hear that and says, "Oh, well, then it's a big deal." But a decision is a decision, I suppose.
You're exactly right. Yeah, 9-0, 5-4 really doesn't matter at the end of the day. Sometimes if you get a closer split, maybe there will be, something in like a dissenting opinion that you can kind of grab onto that might be of relevance in a later case with maybe different facts. But the reality is this was a purely procedural question. 9-0 or 5-4 doesn't matter. A loss is a loss.
I kind of figured that was the case. You kind of heard a lot of talk in the wake of it. With oh no, it was unanimous too. But it's like, hey, it is what it is, So
right.
So the decision was kind of based around that F4A safety exception and the phrase specifically with respect to motor vehicles. In plain terms, kind of what did that one phrase, or why rather, did that one phrase carry so much weight to the court?
Yeah, and so that's a great question. The federal statute here, we call it colloquially at the firm the F Quad A. The F Quad A basically says that states can't regulate routes, rates, or services of brokers or motor carriers. But then there's a huge carve out to that, and the states can regulate routes, rates, and services if it is within the state's safety regulatory authority with respect to motor vehicles. And so there were two hurdles, that the the claimant had to clear here was were these negligent selection lawsuits an exercise of the state's safety regulatory authority? And if so, is it an exercise of safety regulatory authority with respect to motor vehicles? And the court unanimously held in both instances that the answer was yes.
Interesting. So a lot of coverage, tries to depict this as some kind of brand new responsibility. This didn't exist before. This is something that brokers, didn't have to deal with, but you've made the point and it's obviously clear that that's not the case. In many states, something like this already existed, and if you weren't locking down kind of your procedures beforehand, you were already kind of in trouble. So what did this why do you think, the kind of uproar, like what really changed? I mean,
Right.
aside from the obvious here.
Yeah, no, I mean, I think I mean, I, I think there's a lot of ways to answer that question, right? Some of it is just, perspective or the understanding of the listener, basically, of who's hearing about the case. But in the context of really what what actually changed is we lost an important defense to claims that, we've had this liability since at least 2004 with the Schramm v. Foster case. And so we've been defending those lawsuits right up until, when the decision was handed down on May 14th, and we'll continue to defend them on the merits. I think what has changed is really only within the past several years have we been winning preemption claims as a defense in this type of a lawsuit. And so we've lost a defense that we've had for the last, I would say, 6 or 7 years in some jurisdictions. A defense you would always raise. Sometimes you would win, sometimes you would lose. The nice thing about that defense is if you win that defense, you can usually win at an early stage in the proceedings and avoid some of the additional uncertainty and the cost and expense associated to the litigation. But ultimately, we continue to now unfortunately, it's clear that we no longer have this important defense, and I'm sure we'll get into more about, why it was an important defense in the discussion here. But brokers were defending these cases, have continued to have to defend them in certain jurisdictions, and now it's just clear that we're going to have to defend on the merits everywhere.
So obviously, but prior to May 14th, prior to Montgomery, a broker could go to the right circuit and use a preemption to get a favorable ruling. Right now, those are going to a discovery process. What does that do now? What does that do for the cost, the timeline of a claim? Like,
Yeah, it ratchets everything up, in like factors, like multiple instances, right? So the cost of the defending the lawsuit goes way up. If we can't, if we're comparing winning on a motion for dismissal early in the proceeding versus going through discovery and even trying to win on summary judgment before we get to the jury, significant cost and expense there, discovery, depositions, etc., filing a motion for summary judgment, which is essentially asking the court to say, hey, look, there's no facts in dispute here, judge. All the facts are on the table. You should just apply the facts to the existing law and render a decision. Sometimes we can, get a decision at the summary judgment stage. Doesn't mean it's going to be a winning decision, but sometimes you can get that decision. But if you don't, then you're in front of the jury, and obviously what really happens there. So yes, the timeline of the case is going to get extended considerably. The cost, but then also the settlement pressure, right? I mean, there's going to be significant settlement pressure if you're talking about, hey, am I going to be in front of the jury after maybe losing a motion for summary judgment, where the plaintiff now feels a little bit emboldened, and you feel like you're rolling the dice in front of the jury. So you've got some significant pressure there to try to settle the case potentially.
Yeah, I think we're definitely seeing, people are responding in a variety of ways to this. And some of it is, really useful. They're taking things more seriously. But in your experience, how are people either not taking this seriously enough? Some people might say, what, we're good. We've been doing this right. We've been doing this all above board. Nothing to worry about here. Or people are saying, oh man, we're toast, and they're kind of either looking for a way out or something like that. Or even in some cases, they're going to third parties that promise them, the world and basically say, we can fix this for you. Just come work with us. So what are some of the things that you're seeing, some pitfalls on either side of the aisle there?
Yeah, that's a great question and a great point. To your point, we are seeing kind of all every and any response to the decision, right? So I would say, for those that are saying, hey, this is just par for the course, steady as you go, no change. We've had to, defend these cases from day one, and we will continue to defend them. That might be completely correct and accurate if you had a buttoned down carrier vetting policy that you're following, that you understand, that you've implemented, and you're sticking with. Um, what I would say, and I think everybody understands, this decision did not change. The fundamental question in these negligent selection lawsuits is, did you exercise reasonable care when you selected that motor carrier? Obviously, that's a question that doesn't have an answer, even in any given state, but the standard would be different in every state, and it's going to be dictated by the facts in front of the court. I think for, those parties that are saying, hey, there's nothing to see here, we don't need to worry about this. I would say that since the decision, it does seem like the industry is moving towards tightening up carrier vetting and selection standards in whatever form or fashion that may be, right? But we are seeing, I would say it's fair to say, brokers moving away from maybe if they were historically authorized to haul, and that was essentially the only test, to adopting some more limiting standards that are going to cut some carriers out of that available capacity. So if that's the kind of vetting protocol that you had prior to the decision, I would say it's possible that the industry is shifting a little bit underneath you, and you may not know that. And so that's the one for those folks that are saying, "Hey, it's par for the course. We don't have to do anything." Now, if you already had more robust vetting standards and you're applying them and they're consistent, then maybe that's correct, and maybe you were already, where the industry is shifting. But I would say for those parties, that would be the question I would be asking myself. As far as for folks that are saying, this is the end of the world and it's doom and gloom, um, it's not. I would say I think there might it's hard to say there's going to be any good coming out of this decision. What I do think is it's possible we start to see a more coalescing around kind of an industry standard or an industry norm, with respect to vetting, or maybe even it actually causes, Congress, to take action here and give us, an actual national vetting standard. Um, but for those that are so it's possible that we get some, guidance here that will give brokers more of a North Star to point to, right, in their vetting. Um, I would say that in the short term, I think the pain, and I'm sorry, I should conclude that thought. In defending these cases, the defense bar has a pretty decent track record, right, of actually defending them on the merits. Where things get dicey again is with the pressure to settle the claims, before you're in front of the jury, right? And then the last thing I'll say is I think where the short-term pain is going to be, two things. I think we're going to see claims coming out of the woodwork that were kind of sitting dormant while this case was pending before the Supreme Court. We've already seen, several of our broker clients have been hit with claims from accidents that clearly could have been brought prior to this decision. And then secondly, just the uncertainty in the insurance market, right, with everybody essentially assuming, and we're seeing that rates are going up, but still having a hard time kind of pegging where that's actually going to land, in the long term. So, some maybe looking forward, maybe some good as far as some coalescing around some standards, that will help us inform juries, right, of what the standards ought to be. But then in the short term, maybe some pain around the insurance renewals and some claims that maybe weren't going to be brought that might now come to fruition.
Out of curiosity, real quick, like what does the creation of a standard look like? Do you just need some cases to go through to start actually, because it's like, It feels like such a nebulous concept, a standard.
Well, that's a great question. So the industry standard doesn't necessarily mean reasonable care, right? So we talked about, right, the test at law is, did I exercise reasonable care in my selection of the motor carrier? And technically, the way that we start to develop that standard would be through, you know, case law where courts, or juries are making a decision about, did that broker exercise reasonable care. There are a million problems with that approach. We've been defending these cases for 20 years and we still don't have a standard. Some of that's because carrier vetting has changed every few years. There used to be SEA scores, and then there were carrier basics, and then the carrier basics went dark. And so all those were different paradigms. But even, since the scores went dark, 10 years ago, we don't have a ton of case law. And part of the reason is so many of these cases settle that we don't, as attorneys, what we need to be able to put in front of the court is a published decision by a court, ideally an appellate court, that would say, well, this was the standard in this case. This was the carrier's qualifications. This is the state's law that was being applied. And if hiring that carrier was reasonable, then hiring this carrier in our current case was reasonable. That's what it should look like. But, absent decades of decisions, there's so many different factors at play here that it's going to be really hard to get a standard through case law. An industry standard, like I said, complying with industry standards doesn't mean by definition that the jury is required to find that you exercise reasonable care, but it's a pretty good metric, right? It's something, and the way that we get to an industry standard, um, my guess, honestly, I mean, you've seen some groups are already out there trying to establish that industry standard. Certainly, if we could get Congress or the FMCSA to give us that industry standard, that would be fantastic. Um, Absent anything there, I think where we would honestly start to see it is maybe getting pushed down through the insurance market and insurance underwriters saying, if you want to have broker liability or contingent auto liability, these are the requirements that we're going to expect you to impose on your carrier base. And I think that's, now I don't love that answer. That obviously the insurance underwriters maybe are looking for, would eventually be looking for standards that are more strict than is pragmatic for a broker to apply and still maintain sufficient capacity. But I think if we're going to see some sort of an industry standard develop, and obviously, there's a possibility that it comes through other means. I mean, obviously TIA would be an example, or, like I said, the good work that it's doing, in Congress and at the FMCSA.
Who defines some of these things? Like, who defines what reasonable care is? Is that part of the issue? Is it kind of a nebulous phrase that a lawyer on one side says it's this, the other one says no, actually it's this, and the jury says, "I'll decide what reasonable care." I don't know, like, where do these decisions come from?
You're exactly right. That's exactly how it plays out. The plaintiff will have an expert, the defendant will have an expert, and then it's left to the jury to decide, the broker exercise reasonable care, right? And again, that's the problem with these cases, right? Is like we're asking a jury that has absolutely no experience with transportation or with brokerage, to an assessment of what was reasonable. And we're on our back foot when we're doing it, right? Like, but the very fact that we're in front of a jury means something bad happened. So, the plaintiff gets to start from the proposition that whatever you did didn't work because somebody got hurt and we're in court, right? And obviously that's not the right way to think about it. Our duty isn't to be perfect. It's not to avoid every single accident. I mean, I wish that was realistic and I wish that was the case. Obviously, I drive on the roads, my family drives on the roads. We all get that. But the reality is that um, you know bad things are going to happen, and the question of what did we exercise reasonable care, and asking the jury to have an informed opinion in that context where something bad happened to somebody, we're just on our back foot. And it's very different. It's the same question that the jury gets asked as far as, hey, is the motor carrier, is the driver liable for this accident, right? Well, you know, the difference there being, most people have a little bit of, most people who have been on a jury have driven, right? And they understand the rules of the road a little bit. You can kind of tell what negligence is when you have that experience and that background. Here, we're asking them to make that assessment when they have no understanding of what brokers do, what information is available to brokers, and how predictive that information is with respect to, crash risk and the relative safety of the motor carrier. And the answer is, I think you can tell, in my opinion, is it's not very predictive, right? I mean, if it was, we wouldn't be having this discussion.
Hey, this episode of Freight Beat is brought to you in part by the TIA Institute for Research and Education. The TIA IRE was founded to help brokers and brokerage employees expand their knowledge base and be ready for anything in its fast paced industry. Members are given unlimited access to a comprehensive set of on demand complimentary courses that cover every aspect of the business. Whether you're interested in how to better leverage intermodal opportunities, you're curious about how you can use artificial intelligence in your everyday work at a brokerage, or you want to dig into the latest in cargo theft and fraud and how you can fight back, TIA IRE is here to keep you on the front foot of brokerage education. Head to tianet.org/education to learn more. So let's talk about other ways brokers can protect themselves. One of those is obviously contracting terms, conditions that they submit to with their carriers. So the things people sign. Right. This is your day job. This is what you are into. So when you engage with a new broker client and you look at their paperwork, what are the holes you see, the soft spots, the things they're missing, and what do you do to guide them?
Right. Yeah. It's a good. So it's a tricky issue in this way, right? I mean, there's some things that we can do contractually to try to protect the broker. But I hate to say this, but the reality is that the claimant in these cases is a complete stranger to our contract, right? And so, you know, our contract isn't going to protect us against, directly. It's not going to have waivers or indemnities with the plaintiff, right? And so the only thing we can do is kind of how can we protect ourselves indirectly, right? And there's a few things we can do there, certainly. I mean, a robust broker carrier agreement is a must, and I would say that's table stakes for any broker, and most brokers do, or most brokers have decent broker carrier contracts, but we want that contract to, make it very clear that we're interested in the end result, but the motor carrier controls the method, manner, and means of performing its services, right? We are there to engage and qualify the motor carrier, but the motor carrier is solely responsible for qualifying and engaging its personnel. We want the motor carrier to agree to comply with all applicable laws, to agree to, comply with the FMCSRs, the Federal Motor Carrier Safety Regulations, et cetera. But we don't want to exercise too much control over that carrier in the contract, right? Those aspects of its business are its business. Our business is being a broker and selecting that third party motor carrier. Obviously, we want indemnities from the motor carrier. Again, table stakes. Any motor carrier is going to agree to that. um, Really the indemnity is usually only as good as the insurance standing behind it, right? So in other words, we get the motor carrier agreeing to protect us and our customer against highway accident liability claims. That's great, but often there's only a pot of maybe $1 million there to protect against the claims, and that's why then the plaintiff sues up the chain. The As far as customer facing agreements, since Montgomery, there's a couple ways I should address this question. Um, the if For the broker's default terms and conditions, so maybe, I would always recommend a broker have default terms, not necessarily a signed contract. Just these are our terms and conditions. If we provide you services, we these are the terms that govern, absent a signed contract that waives these terms. In those terms, the broker, could uh, disclaim any liability to the customer related to, negligent selection. Most customers, if they saw that, would strenuously object to it. But in any event, that's only a protection against, clarifying that we don't have to indemnify the customer against a negligent selection claim, which they may not get sued for negligent selection anyway, right? Because we were between them and the motor carrier. Um, a- as you guys know, and most people listening are going to know, most brokers are regularly required to sign the customer's paper, and those customer contracts can be very onerous. in addressing those contracts, since Montgomery, we've seen a heavy emphasis from customers on carrier vetting and wanting to impose obligations on brokers with respect to carrier vetting. And we've been trying to educate those customers a little bit and go back to them and say, look, don't impose your vetting standards. Like, that's part of the reason you hire a broker, is because we're really good at selecting motor carriers. It's what we do. If you start imposing your selection criteria, you're going to put yourself in the firing line on that liability, and there's no reason for you to do that, right? Let us do what we do and take your vetting standards out of the contract. So, that's something I would say post Montgomery, we've seen a big uptick already in customers that are kind of spooked by the decision. And I think kind of failing to understand that, look, yes, as a shipper, you can have direct liability for negligent selection just like a broker can. But when you hire a broker, you take a lot of that risk off the table, right? And so you could, if we're talking about, again, like the elusive silver linings out of this case, that might be one of them, is that some shippers that were reluctant to use brokers before are now going to say, you know what? If the broker is going to protect me from a negligent selection claim, then I'll work with the broker, right? And so, um, again, maybe a silver lining there. I don't, to the extent you can call it that.
Mm.
Yeah, there's definitely somebody was bringing up this kind of paradox where I think everybody's kind of feeling it. It's like you want to look at your relationships closer, but you don't want to look at them so close that you're doing their job, that you're starting to actually go, over the line and, you know, actually do the work that somebody else should be doing. And it seems to be happening with kind of everybody. It was an interesting point that was brought up. But um out of curiosity, so you obviously work with quite a few clients, but a lot of folks that I think are fearing this the most are the ones with the most to lose. It's like if you're a bigger company with good insurance and everything like that, if there are a few cases, you'll survive it. While some people feel like one case could take them down, and with that comes the fact that a lot of times they don't have in-house legal counsel. They don't have somebody to talk to. They're trying to glom on things like this podcast, conversations with folks like you, opinions that you make. But what would you recommend to somebody, who is feeling that heat and doesn't necessarily have someone to turn to in that way? Like, what is TIA membership like? Perhaps.
Oh, yeah, yeah. I mean, you stole my thunder, which is great. But you're exactly right. I think I've had the good fortune to be attending, the Capital Ideas Conference now for, well over a decade, right? And I, in my seat, I attend a lot of different trade association events, or have throughout the years, and for different, and again for different trade associations. And I would say from day one, I've been blown away by the amount of content and education the TIA offers its members. I mean, when you go to convention, you could be forgiven for forgetting that there's a trade show floor almost, and that's tongue in cheek, right? The trade show is amazing, but my point being that there is so much content, and it's and much of it very high level, right? I mean, I've got a lot of competitors in this space that do what I do, and as much as I'd love to tell you I'm the best that there is, there's a lot of smart folks out there, both on the legal side and in other areas. And so, brokers can go to TIA and really make sure that they are, getting cutting edge, good advice, good talking points, actionable items that they can take back and implement. The other things I would say would be, continue to do what you're doing. Yeah, dial into, podcasts, webinars, etc. Um, don't necessarily discount. I get it. It's not, nobody likes to call the attorney. Don't necessarily discount or tell yourself that it's going to be too expensive. Most attorneys should be willing to sit down with you, have an initial consult, learn a little bit about your business, either identify what they think some low-hanging fruit might be for you or hear your issues, and should be able to give you, if it's the right type of project, an estimate of the cost. I mean, don't call an attorney with a large esoteric lawsuit and expect a very rifle shot estimate of fees. But if you need a couple of documents drafted, yeah, they should be able to give you a pretty good estimate of the fees there. Last thing I'll say is same thing with your insurance professionals, right? If you're working with, somebody local that you've known for a long time, that's great, and they might know your business and they might be wonderful people. There are a lot of people that very much specialize in this space that understand the coverages, understand the risks, understand, that there are some markets there that might not be known to, again, your local kind of run-of-the-mill insurance agent. So, that's another place where you can really get some value and some good bang for the buck is, having somebody come in and kind of walk you through that underwriting process, and helping you get, essentially ready for market, if you will. I think those are all, you know, kind of easy steps that you can take to get some insight and some intel on where you need to be.
So obviously Montgomery is a big talking point. Let's look elsewhere, right? There's many things happening in the brokerage world. I mean, specifically right now, there's a fight over how much a carrier gets to see about a broker's cut on a load, right? The broker transparency discussion. Right now, a broker can have the carrier waive that look. FMCSA is weighing a change that would make it non-waivable with the numbers turned over inside 2 days. You've been tracking this. What does it look like? Where does it stand right now? And why does it matter for those who haven't really put a lot of thought into it?
Well, hopefully it doesn't matter, right? I mean, hopefully we did enough in comments to the agency to talk them off this silly ledge, right? And so I think for everybody listening in, right? I mean, again, the rules here, the broker transparency rules that would require disclosure of the amount paid to the broker, if the carrier asked for it. And, the way the FMCSA said that in the proposed rules, well, you can still require the carrier to waive that right, but if they request the documents and you don't give them to the carrier, then that is going to be a potentially finable offense on the part of the broker, and could even result in maybe loss of authority. And so it is important in those regards. I think, the eh, again, it's just a silly requirement. We don't see this in any other aspect of the economy, right? Where, you have a legal duty to disclose your rates to a downstream provider. I don't know why this regulation, frankly, even exists. Well, I do know why it exists. It exists from back in the day when brokers were considered agents of one party or the other, and as an agent, you would have a duty maybe to disclose. But today, that's just not how the industry operates whatsoever. This isn't going to change rates, right? I mean, the rates are set by the market. They're not set by, if brokers could set rates, I would be a broker and I would be retired already, right? I mean, it's just not how the world works. And so, it's kind of I think now, so where does the thing stand right now? The good news is no news is good news on this, right? I mean, so the agency put out, their request for comment, they received comments. If they don't do anything, then nothing happens and we are status quo. They have announced, so I think I don't frankly remember if it's quarterly or every 6 months, they put out a regulatory agenda that kind of tells the status of every rulemaking. And on this one, they have flagged that there is going to be a second notice of proposed rulemaking. So that's unique. We don't normally, that would suggest that there's going to be a change in what was proposed. Usually it just goes, they ask for comments and then they take the comments and they issue a final rule. Here, they've suggested that they're going to propose a different rule, and usually that means that whatever they're proposing would be so different than what was previously proposed that they feel like they have to give the industry the ability to comment again, or the rule would be subject to challenge because once they change the rule so much that your ability to comment on the first rule is irrelevant in the second rule because the second rule is so different that you didn't get a chance to comment. And so it would suggest that maybe they're looking at a very different approach here, but we just haven't seen it yet, and they're under no requirement to act in any sort of a timely manner. So again, in the meantime, no news is good news. I'm cautiously optimistic that the good comments that were submitted by the industry, and the fact that they have tipped their hand to suggest that the rules can maybe look a little bit different, um, maybe we made some good headway there.
Is there anything further that can be done at the moment, or is it just kind of a waiting game?
I think, well, definitely a waiting game. Other than, I mean, certainly, to the extent that the industry is essentially able to. Usually, we think of lobbying as lobbying to Congress, right? But I mean, to the extent that the agency can, or the industry can lobby, kind of the FMCSA. Great. I mean, I think the FMCSA is very clear about where our position is on this. I don't know that additional hand wringing is going to move the needle. But then certainly, the other thing that could happen. So th- again, this would be an act by a federal regulatory agency. Congress could come in over the top, right? Congress could come in and say, you know what, this rule needs to go away. Either you got to get rid of the rule that's on the books and you can't pass a new rule, or if you pass a rule, it has to, do X, Y, or Z. So that's something that could happen. I don't see necessarily that happening. I mean, obviously, I think the bigger fish that we're all trying to fry, on the legislative side is the highway accident liability.
Interesting. So, just back to Montgomery again. So I think technology obviously kind of is this double-edged sword. It's like, with everything changing so quickly and so many technology companies coming out there promising the world and then some. When and then we also hear people say technology is good, but the human first approach will always keep you out of hot water, and that's extremely important. So how would you recommend a customer not only wade through the myriad companies that are trying to say that they can help them from a technology side? How can they like choose a good technology partner? But how can they also ensure that they keep that human touch in there so that they're not over indexing on what technology can do and in the process leaving up something to happen in the meantime?
Right. No, yeah, and I think that's a very prescient question for this industry, right? I mean, I've been saying for years now that, if you haven't figured it out, freight and logistics and brokerage in particular is a tech industry, right? I mean, between the data, the need for automation, et cetera, the value of the data, it's absolutely a tech industry. And, when you go to trade shows, the number of tech providers, right, has just exploded over the past several years. My so, my here's my, kind of from the outside looking in, because I don't when I go to a TIA as an example, one thing I do try to do is hit up some of the tech vendors, and I'll just say, "Hey, I'm sorry, this is gonna be a waste of your time because I'm not a potential customer, but I would love to see what your system does," right? A lot of my clients are using these systems, and I kinda wanna know what they have available to them, at least be conversant, right? And the number of options out there is astounding. They all look really slick, when you try to use them, in real time. I guess I would say from my perspective as an attorney, the things that I would be interested in are, things like, where's your data coming from, right? Is this like a real time, if I'm using you for carrier safety vetting as an example, I want to know that you're getting a daily download from the FMCSA via an API, and I want to know that you're going to, push that and correlate that to my carrier stable and pull out the carriers that I've told you to pull out that don't meet my criteria, right? I mean, those are, again, that's kind of table stakes, I feel like, for a technology stack at this point. I would say, I also want to understand, like, well, what records are going to be available and how are they going to be maintained? Am I going to be able to see only current state, or am I going to be able to see the history of this carrier and their qualifications and what they were on any given day, right? Because I might not even hear about an accident until, I mean, unfortunately, we've seen that where, we don't even know that the accident occurred because somehow the load's still delivered, and that there was no service drop, and because of that we didn't know, the carrier didn't perform its contractual duty to tell us about the accident, and so we're left scrambling after the fact, trying to look at that carrier's qualifications. And so does my technology stack allow me to see, in real or in after the fact, right, what the carrier's qualifications were every time that I use that carrier? I would say as far as, and so again, that's kind of the main like carrier vetting and the TMS system as far as our carrier procurement system. I would say anything beyond that, and to get to your question on the human touch, right? I guess that one I don't have much of a legal answer for. I just have a human answer for that, right? It's like we all, get frustrated when we can't get to a person or when we can't, navigate the call tree or when the chat feature just gives us a bunch of links, right, to, you know, here's your problem, here's your problem. And no, none of those are my problem. My problem is I can't talk to a human and explain my problem, right? So I think that, and that's not just customer facing, right? I mean, the drivers and the carriers are such an important part of what brokers do that I think if you want to continue, to be a broker that carriers and their drivers, want to work with, that it would behoove you to, think about those touch points and think about where and how people can get to you, and can they get useful, helpful, data or information. I mean, as a carrier is trying to do the right thing and they've come up with an issue on, added delivery, and they're trying to call and trying to reach out and they can't get to somebody, they're just going to throw up their hands and maybe make a poor decision, right? Maybe leave somewhere they shouldn't have left, or maybe, do something that they shouldn't have done. Whereas if they could have gotten through to somebody, you could have, gotten them a response and gotten them an answer, or maybe, rustled up a way to get them an accessorial paid that, probably needed to be paid to smooth over, whatever the thing was, right? So I think that as much as anything to me is like, hey, yeah, the tech is great, and I'm a huge proponent of it. I'm a huge proponent of automation and especially with carrier vetting, right? I want to take the human error element out of carrier vetting. I want that to be an automated process. But at the same time, I want, like there needs to be that ability to reach out and call somebody who can actually fix a problem.
Today's episode of Freightbeat is brought to you in part by TIA Bond. TIA Bond, powered by Avalon Risk Management, is the flagship bond program backed by TIA's values as a leader and advocate for 3PL companies. With the backing of Avalon, it's the best choice for brokers looking for assurance. From higher bond limits than competing products to a dedicated staff of underwriters and claim experts, as well as the TIA bond certificate that shows you're committed to professionalism above and beyond the standard, it's the best choice in the market. If you're interested in learning more, head to tianet.org/bond. Thanks again to Avalon for powering this incredible program.
So let's look forward for a few years, right? A lot has happened in the last few months to the world of brokerage and the world of logistics, but this with the F Quad A shield gone, suits are like you mentioned, suits are coming out of the woodwork that people had probably kind of put on the back burner until this one got decided. How do you see broker contracts? How do you see things like insurance, like you didn't talk about before, carrier vetting? How do you see that shifting over the next few years? What should brokers be kind of keeping an eye out for?
Yeah, it'll be interesting, right? I mean, I think we're going to see, hopefully not overcorrection in the immediate term. I mean, I think there was, you know, an immediate knee-jerk reaction to, um, well, I mean, all sorts of things, frankly, right after the decision came down, right? People saying, oh, what insurance is, we're either not going to be able to get insurance or it's going to go up, 3 and 4 times and we won't be able to get the same limits. And maybe those things are true. Um, so far, that hasn't been our experience, right? And I think, things like carrier vetting standards, hopefully, again, I think there's a bit of a knee jerk, maybe slight overcorrection immediately after the decision. I think with time, you know, I think the reality is going to set in for a lot of people that, hey, we really, you know, we have to really sit down and model and do some modeling with our carrier vetting. We can't just adopt standards that we're hearing about in the industry unless we sit down and compare those to our carrier base and make sure that that would give us enough, you know, ability to continue to move freight while still cutting out, the outliers, right? The ones that are, probably of a marginal, qualification. And so I think we're going to continue to see, I think, course correction and, maybe a little bit of overcorrection in each direction until we get, to a steady state. I do think we're going to start to see, like I said, some more uh, some more dialogue on how people are vetting, what they're vetting to. And I think we're going to start to see some coalescing around standards within the industry in a way that we didn't before because there wasn't much of an incentive to do that, right? Again, a lot of carriers or brokers, excuse me, were saying authorized to haul. And then so much of the vetting has been fraud vetting. And I should make a point there to say, again, I'm a big proponent of safety vetting being ideally automated, and that's not because machines do it better. It is for a broker of a certain scope and scale. I think it just makes sense if you can automate that process. Um, but then we don't want to see ready exceptions to safety vetting, right? I mean, in other words, it's like, well, if the policy allows for an exception there, then we follow the policy if it allows for an exception. But we don't just override our policy because that's bad evidence in the event of an accident. I would put fraud vetting in a different category than that, right? So much of the fraud vetting standards are, I'll use the fancy legal term, squishy. I would say a lot of the fraud vetting is squishy, and so, things like, well, was there a change in an address or was there a change in, insurance or whatever the case may be, right? And some of those can absolutely be huge red flags and brokers have been burnt by those issues. But there are also brokers that know, their carrier base and, oh, well, no, I know this carrier and I know they actually did move their location. And if we've got a system that says, we won't use you when you've had a change in address, but we want to go in and override that in this one instance, go ahead and override that, right? So I think as we're thinking about carrier vetting, I think we're going to start to see more discussion of, hey, what's safety vetting and where should we, not be making exceptions and where's fraud vetting? And again, I want to be very clear. I'm not suggesting that brokers should be making, willy-nilly exclude exceptions to fraud vetting. It's a huge problem, and it's one where if you crack the door, fraud's going to come into your operation. I'm just saying if you're aware of a reason why, oh, well, that's not a concern on in this particular instance, you can make some exceptions there. And I think again, we're going to start to see some bifurcated, fraud vetting versus safety vetting as things go on. I think we're going to see some coalescing on the safety vetting. I think the fraud vetting is going to continue to be as fast as the technology allows us to adopt new fraud vetting, metrics or tools, we're going to continue to adopt those. I think that's going to be an area that continues to kind of explode over the next few years. On the contracting side, again, I would say, maybe some understanding. Like, I think we're going to start to have the ability to educate the shipping public that, hey, when you use a broker, you are protecting yourself as a practical matter from your own negligent selection liability, right? And you should be using brokers. You shouldn't be imposing carrier qualifications on your brokers. I think we're going to be able to tell that story to the shippers of the world, and hopefully have them start to come around to understanding like, okay, we really need to be more hands off with our broker and let the broker do what the broker does really well.
Awesome. Well, the hardest part about running this podcast is not be able to talk as long as we wish. We want to be respectful of your time, Nathaniel, and we really appreciated this conversation. So, like we said at the beginning, you work at Scopelitis as a partner. Is there any other way you would tell folks to get in touch with you? Any work that you're doing right now that you think is interesting, or anything you want to kind of sign out with?
Yeah, well, thank you for that. Thank you again for the opportunity just to be here. Just appreciate the relationship with TIA. So, thank you very much. I would say it's all interesting work. We're doing a lot of carrier vetting reviews right now. I guess parting shot on the carrier vetting. I would say this. You know, if I were to ask you as a broker, what's your carrier selection policy, and you tell me the system that you're using, then we need to talk, right? Like the system is not your carrier vetting. It is a tool that you use to perform your and so I'll say it that way. Like if you don't know what your carrier vetting and your policy is, you really should, right? I mean, part of the defense of these claims is, you know, professionalizing around that issue, right? We want to present that we understand that vetting is important. We want to be able to put forward a very nice, published policy, and maybe it's multiple policies, one for, a group that's doing the actual onboarding of new carriers, one for the group that's actually, tendering loads out on a daily basis. So just think about professionalizing your carrier vetting, because that's, as much as anything, since May 14th, that's what I've been dealing with clients on, I would say, is, really getting those policies dialed in. So other than that, if you need to reach out, you will see me in 2027 at TIA Capital Ideas. I will be stumbling around there. If you need to see me before then, you can find me at our website, just scopelitis.com. And I appreciate the opportunity, gentlemen, and hopefully we can keep plugging away here for the industry and making things a little better, one thing at a time.
Fantastic. Yeah. Hey, I agree. Well, again, thank you, Nathaniel, for joining us, and thank you to everyone for listening and or watching wherever it may be. Do us a favor, as always, please rate, review, and subscribe. Give us a thumbs up there on YouTube if you're watching it. Aside from that, I have been Merritt for Freight Beat Podcast.
I've been Patrick.
Also for the Freight Beat Podcast.
Yes.
And
Yep.
we will see you next time.